I'm not, so here's the thing. He's obviously a convicted felon, picked up an unlawful possession of a felon over in Jeff Parish, picked up another one after that over here, so.
Hit me, yo. Watching how them opera boys get sentenced. You know how the f***'s going on, man. Y'all boys tuned into that Oouchie court watch. Well, we taking it straight from the jail cell to the judge. Hear me?
So, again, you are Jarrett Matthews, and Mr. Matthews, it's cause number 23, DCCR 1211, and Mr. Matthews is charged with unlawful possession of a firearm by a felon from September 13th of 2022. Mr. Kimler has filed a motion asking that I reduce his bond, and bond is currently set at $30,000, it looks like. Is that correct?
Is that right?
Mr. Kimler?
I think it was more than, I thought it was, it's 100 is what I thought.
So it was initially set at 30. So let me see here. Okay. So I wonder why.
We'll take 30, Your Honor.
I'm just looking at, okay, so apparently back in September of 2022, there was a bond set. And then I guess Mr. Matthews made that bond.
Then he went to custody in Louisiana and stayed in custody.
And when he got back, it was reevaluated in a bond set at $100,000. So I have and will take judicial notice of the court's file, including the probable cause affidavit, the magistration documentation that was used at the jail, and also the public safety report. Mr. Kimler, you may proceed.
Your Honor, I suppose the initial bond was $30,000, and then, of course, he accrued the cases in Louisiana, was in custody on the next court date, so was unable to make that. I don't think there's been any type of intervening circumstances from the time that he got the $30,000 bond and now that would warrant an increase in the bond other than just being out of state incarcerated.
Well, that we didn't have the public safety report system back in 2022, so I'm sure the new magistration process, that magistrate looked at the several pages that are included in that.
I'll just let Mr. Matthews address the court, then, Your Honor, he can explain his current situation.
Raise your right hand the best you can, please, sir. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, go ahead.
Explain to the court what your current situation is as far as your living arrangements, where you would be residing, and what your plans are.
I still stay in Lake Charles with my mom. From when I bonded out here the first time, I never missed court. I never failed the drug test or any of that.
But you were in custody in Louisiana for something between then and now?
I caught a charge prior to the charge I caught out here.
Okay.
This is my most previous charge.
Most recent.
Most recent charge.
And what was that charge?
It was a convicted felon with a firearm charge.
Jefferson Parish, right?
Yes,
And what was your sentence?
4 years.
Okay.
I was in the military 7 years. I kind of have a little PTSD. I was going to dental appointments before I got incarcerated.
All right. Anything else?
It's a 4-year offer, Your Honor. He's wanting to try to get probation, so I would like to try to get him out, maybe to get established a little bit to show that if we come back on a contested sentencing that he could do the probation. Is that what you need?
Yes, sir.
Did we have a hold on him when he was in?
It's my understanding, Judge, and the reason for the offer being, obviously you see the offense date is quite
Right.
old. He should have had a hold at some point in time. I obviously appreciate his military service and will be willing to work with him on that. My problem being is that he's not a resident of this county.
Right.
Well, from
So
Veterans Court, right? But I
Right.
think we could transfer the probation.
well, I guess I mean, if he wants a probation, that's one thing, and that's up to them to offer that. If he has been incarcerated for most of this time, then we can make that, even if we didn't have a hold, I can make a finding that we should have, and if you get that documentation on how long he was in custody there between the time of the indictment, nothing before the indictment, but the time of this indictment and now, okay, so obviously it would need to go back if he was in custody, but I would need documentation of that. And so I don't know if that's something you guys want to take into consideration.
And that's what my notes had reflected, the credit for the time that I was anticipating we would have had a hold, because he's been in custody at least 18 months now.
Right, which, I mean,
He's asking
he would have enough time under his belt. And I understand what he's asking, but I don't know if y'all want to visit about that opportunity.
He wants an opportunity to do probation, so.
Well, that's between y'all then, and so
Well, it
then,
could be a-
all right, back to the bond,
It could be a
so,
gap, Your Honor.
I mean, I'm not, so here's the thing, he's obviously a convicted felon, picked up an unlawful possession of a felon over in Jeff Parish, picked up another one after that over here, so at this time, based on all of the information that I've received, again, from that public safety report as well as the criminal history, the facts of the case, I'm going to deny the motion to reduce the bond. You guys can visit about any options, and then we'll get it set for an announcement.
Yes, sir. I'll
right.
try to maybe figure something out.
All right, thanks.
We'll talk.
Mr. Kimler, on Jarrett Matthews, do you have your discovery certification? Okay. All
He's decided to go with the cap, Your Honor.
right, sir, again, you're Jarrett Matthews, and will your client waive the formal reading of the indictment?
So,
Mr. Matthews, in cause number 23, DCCR 1211, you're charged with a third-degree felony offense of unlawful possession of a firearm-by-felon from September 13th of 2022, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 4 years in prison, which means you're leaving your punishment up to me. As long as I give you 4 years or less, then you cannot appeal that decision. Do you understand? You have an absolute right to have a jury come in and determine two things. One, if you're guilty or not, and then you could leave your punishment up to them if they find you guilty. If we go forward this way, you're waiving that right, and is that what you want to do? State tenders number 1.
no objection.
It's admitted. Is there any evidence that Mr. Matthews is not competent?
None that word.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report that will give me more information about you and your case, and then we'll come back later for sentencing. All right, you can go back with the bailiff. Good morning, you're Travion Thomas. And will your client waive the formal reading of the indictment?
It will, Your Honor.
And, okay, Mr. Thomas, let me do this.
It's enhanced to a third.
Gotcha.
State bill enhanced to a third.
Thank you. Mr. Thomas, in cause number 25, DCCR 1151, you're charged with the state jail felony offense of theft of property with previous convictions from June 11th of 2025. The indictment alleges you were previously convicted of theft July 17th of 2023 and then again April 10th of 2025. It further alleges that you were convicted of possession of a controlled substance, a state jail felony, April 25th of 2013, and after that was final, you were convicted of forgery of a financial instrument, a state jail felony, September 11th of 2015. And how do you plead to that charge? And are those prior convictions all true? Did you enter your plea of guilty and true freely and voluntarily? And because you've actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Thomas is not competent?
No, Your Honor.
All right, Mr. Thomas, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. Find those 2 prior convictions true. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Yes, we put a notation, that the state will not pursue. There's possibly an additional charge, from that night. It was a
Yes.
prohibited item in a.
Yes, I saw that, and that's part of that agreement, correct, Mr.
That's
Coleman?
right. Yes, Judge, the unfiled possession of a prohibited item in a correctional facility.
Okay, thank you, Mr. Coleman. All right, you can go back with the bailiff.
Watch, we're on the scene. Truths unravel, and what does it mean? In the halls where stories clash, Oouchie court watch quick as a flash.